Continue. It's still telling me I'm in a practice session. Shoot. Okay, webinars being, it's telling me I'm still in a practice session. Is anyone, Ron, are you familiar with this? Thanks.
I've never seen that. I've not used this in this mode, so I'm not familiar with it.
Okay, I'm just, would it be terrible if this wasn't enabled? I don't see any attendees. Would it be, maybe, can we maybe close this and everyone log back in or something? Because I think that if I left, or, well, actually, let me make Ron a co-host and then I'll go back in. How's that sound? Okay, I'm gonna make a co-host. Okay. So I'm gonna just leave the webinar and I'll come back. Oh, it's actually assign a new host. Okay.
Oh, it didn't kick us out.
Okay. Okay, now it's started. Okay, welcome everyone to the working group for moral turpitude, which is a working group of the Ad Hoc Commission on the Discipline System here at the State Bar of California. My name is Lisa Chavez, and I'm the director of ORIA, the Office of Research and Institutional Accountability. Before we get started, I'd like to know if there's any member of the public who'd like to make a comment. Go ahead and raise your hand. Let me see, we have, okay. I'm looking at the attending list and I only see State Park employees. Okay, so we'll have no public comments. So we're going to get started. So let me share my screen and we can go over the agenda for today. Looks like we have a quorum, by the way. Oh, no, I'm supposed to take roll. Sorry. Let me just go ahead and take roll. Ellen Tomsky?
Here.
Sean Soleil?
Here.
Melanie Lawrence?
Here.
Okay, so we have a quorum for today's meeting. I'm going to share my screen to go over our agenda for today. Let's see. So the first thing I'm going to do is discuss the 12 matters that were dismissed. I'm getting this. First, empirical analysis, and that's going to be by a case file.
There's a terrible echo. Hard to understand. Maybe if everyone could double check your
Yours. Let's see. Okay, how about now? Can you hear me? Better? Okay, great. Okay, so first we're going to have a discussion of the 12 matters where moral turpitude charge was dismissed. And this is a set of cases that was based on a set of a broader set of cases where we analyzed like a set of cases that made its way to State Bar Court. Some of them had moral turpitude charges, some of them didn't, around 12 of them. 12 matters were instances where the moral turpitude charge was dismissed. You all asked us for some empirical analyses, so we'll be sharing those. And after that, we can have a discussion of the case files that we shared with you. So we sent along the case files associated with those 12 matters, and so we can open it for discussion at that point. After we talk about those 12 matters, we can talk about some research that Araya did on other states. And in particular, we administered a very short survey to participants of the National Association of Bar Council to ask how under what circumstances they charge moral turpitude. And so I can share the results of that. And then we have random diem fictorum here to talk about California's adoptions of ABA Model Rule 8.4, because as you'll see when we present the results of what other states do, the majority of them use Model 8.4, or at least their state's version of Model Rule 8.4 to address issues of moral turpitude. So with that, how does that sound as an agenda for today? So let's get started. Okay. So as a reminder, an analysis we shared previously showed that if you looked at all the 165 matters that the state bar court heard over the last few years that had at least one moral turpitude charge, the respondent was found culpable in the vast majority of them, nearly 93%. But that are around 7%, the moral turpitude charge was dismissed, and that amounted to 12 matters. And so today and that amounts to like 24 cases across that were combined into 12 matters. We did an analysis of the charges associated with these 24 cases across these 12 matters. There was about 104 total charges and 17 moral turpitude charges. So that means that at least one or more of the matters had more than one moral turpitude charge. So the rest of my slides are going to be focused on what we learned about those 12 matters. So first we sought to understand the moral turpitude charges associated with those 12 matters. So as a reminder, there were 17 of them. And like I said, some matters actually had more than one. And what this shows here is that over half of those matters that were dismissed, it had to do with misrepresentation. And it's the most frequent charge. But if you look at those top 3 charges, those occurring most frequently among these 12 matters, they're the same as those occurring most frequently among all those 165 matters that we looked at in previous analyses. So there's no difference between this set of 12 matters and the whole set of 165 matters. We also looked at the reasons why those moral turpitude charges were dismissed, and we found that the most frequent one had to do with that they was dismissed as part of a pretrial stipulation. So again, like the 17 matters, 9 of them were dismissed as part of that. And here's the next one was for good character. And the next 3, as you can see, are around the same also. And we did this again by reading through the case files, those same case files that we shared with you. And then we also did an analysis of all the non-moral turpitude charges that were associated with these 12 matters that were dismissed.
Lisa, can I ask a question?
Associated with those is client neglect or abandonment. So about half of all the charges have to do with that. And then you can see these are the rest of them. Okay, and then so our conclusion is exactly, we tried to look for patterns in other ways, but we really didn't. Perhaps you all have some ideas of what else you'd like to see, but this was really, really the most big picture findings we found that half of the moral turpitude charges that dismissed had to do with misrepresentation, half were dismissed due to pretrial stipulation, and over half of the non-moral turpitude charges had to do with client neglect and abandonment. So this is what we have so far, but I'm happy to take any questions. Sean, did I see you have a question?
Yeah, so for this second bullet here, which I had the same question on an earlier slide. So when you say pretrial stipulation, that's a settlement, basically.
Sean, we can't hear you. Oh, I'm sorry, I can't hear you.
Yeah, I don't know what's happening.
I can hear you.
Let me fix something.
Uh-oh, the plot thickens.
Okay, go ahead.
Lisa, can you hear me now?
Yeah, I can, yes.
Oh, good. Okay. So this may be kind of a dumb question, but just the second, could you share your screen again?
Mm-hmm. Yes.
There we go. So the second bullet, those are basically settlements, right? Pretrial stip.
Yes, pretrial stipulation, yes.
Okay. Interesting. Okay.
So we look, yes, so it's like if you look at all the 17 charges, 9 of them were dismissed as part of the pretrial stipulation.
Okay.
Okay, does anyone have any other questions? So like I said, we looked for tried to find other patterns among the charges, the moral turpitude charges themselves, the non-moral turpitude charges, and this is what we came up with. So if we can, could we?
Question. I'm sorry, Lisa. So I'm a little confused. Does this chart mean that the reason that the moral turpitude charge was dismissed was because of a showing of good character or community service pro bono? I mean, usually those are different determinations. In other words, the court either does or does not find moral turpitude, and then may also find that the discipline imposed is mitigated by mitigating factors. So it would be, I don't think I've ever seen a case where the court said, I'm not going to find moral turpitude because you have good character or you've done community service or have current family problems or no record of discipline. Those would not be the reason that a court would have a no moral turpitude finding. Different parallel tracks.
I see. Well, you know, we drew this based on our readings of the case files. So maybe perhaps we're characterizing it, we're overstating the it's dismissed, but this was in the case files. Well, you all read the case files. Should I ask the staffer who worked on this to like find one in particular, and then he can share it with us?
I'm just seeing that this chart probably isn't that helpful because it's putting together two different considerations as if some of the considerations that are mitigating factors contributed to the finding of no moral turpitude. I'm guessing that's not accurate, and they just kind of inadvertently got combined.
Okay.
Yeah, that seems right. At least for the second and third lines. Lisa, maybe I'm misunderstanding. Did you say that you sent case files to members of the committee, or?
Justin shared a folder that contained all the case files associated with these 12 matters.
Oh, I'm sorry, I think I missed it.
At least 2 or 3 weeks ago, and as well as a document that case by case listed the charges, the moral turpitude charges, reasons for dismissal. So like a little executive summary for each of the 12 matters.
I want to ask a question, if you don't mind. I don't recall having seen that. I'm not saying I didn't receive it, but
Okay.
it would be helpful maybe if it could be recirculated. And I apologize for not giving you the chart that I've been trying to complete. But one question that some of my colleagues in the defense bar have asked is if they allow their client information to be included on the chart, is that going to impact confidentiality? For example, when a case is dismissed and or if it's resolved by an admonition, then it's not public. So I'm a little concerned about including identifying information. I'm thinking perhaps I could label them in some other way, but I'm assuming if I circulate it, it's going to be subject to the blue sky requirements and it will be publicly available. So that's one of the challenges that I'm facing. And so I'm just wondering, in the case file summaries that Justin sent around, is it sanitized in any way, or does it actually have the name of the respondents?
So all matters with the exception of one were public disciplines, and so those files are available online. And so even though we didn't include their name in the Word document, and then the one that was for a public approval we removed all identifying information from that one. So Ellen, did you say you were going to actually, we were thinking that once you saw those 12 cases, maybe you would choose a few from those that you would like to discuss.
Well, what I'm trying to figure out is why there seems to be something, I'm sorry, before I say that, can you remind me what years are included? These 12 cases, they span from, is it 2019? I can't recall the time period that you were looking at.
Okay, I will look right now. So the original matters that reached disposition in the State Bar Court Hearing Department between March 1st, 2019 and May 31st, 2021.
Okay. The reason why I ask is before the staff was tasked with gathering this data, you know, I had talked with Melanie, you know, separately and said, I'm going to see if I can't gather more of like anecdotal reporting. And I started doing that. And so I have a list. It's currently 19 cases. And it covers, it looks like the beginning of 2019 through the summer of 2021. So it's a little bit of a longer period than you're covering. What I haven't done is gone to compare the names of these cases, or at least try to match them with your 12 cases. So I still would like to do that. I just haven't had a chance to do it.
Okay. Okay, so am I hearing that we're going to need to postpone the discussion of those 12 cases? Maybe we can combine the discussion of those 12 cases with when Ellen circulates her list, cases probably till early next year. Then we can just move on with the rest of the presentation. I'll work with Justin on recirculating that folder with the documents.
Yeah, I just searched it. Something may have gone haywire. I can't find it in my email, so
Okay. Okay.
might have gotten stuck in spam, and even though I see a report of that every day, it's conceivable I missed it. Because it's like I'll get 100 instances of spam, and sometimes it's easy to miss the one relevant email.
Okay.
I will say, just for your purposes, when you're looking for it, because I've seen it a couple times now, it came in an email where there was a message about the time and date for this meeting, and it was just then a link to OneDrive. There wasn't an attachment to the email.
I saw a couple of those. So was it one of the doodle polls?
There may have been a doodle poll that came with it.
Yeah. Aha, I see it. But yeah, I don't want to have time to study it, so it makes sense to postpone.
Okay, great. Okay, so let's go ahead and just go on and let's just finish off this presentation. Can you see my screen? Yes, okay, great. Okay. All right, so we'll table that then. Okay, so next we turn to what other states are do about with regarding this misconduct charge. And so we made a survey available to members of the National Organization of Bar Council via their online forum. We have around 11 respondents. And the first question we asked them was, does your jurisdiction utilize moral turpitude as a basis to charge misconduct? Of the 11 states that responded, 8 said yes and 3 said no. If they answered yes, we asked them to choose whether if they chose my jurisdiction's version of the ABA Model Rule 8.4 or another charging vehicle. So the majority of the 8 that said yes chose this first option, their state's version of the ABA Model Rule 8.4, and then 2 said we have another charging vehicle, and these are the 2 right here. So Missouri shared their rule, and then Michigan shared their rule. So I can send all this information, like I can PDF this PowerPoint, or so that you all can, if you wanted to learn more about how these 2 different states, they're using their own charging vehicle to get at this. But majority of them said that they use Model Rule 8.4. And these are the 6 states down here at the bottom that said yes to this answer. And so for the 3 states that said no, we asked them, Well, if you're saying no to this, then what charges would you bring in against an attorney accused of an act of dishonesty or misappropriation or the like? And so Mississippi shared this. And what I think is interesting, I think that 8.4 does refer to a model. I think that is ABA model rule 8.4, but they also listed other rules like this 1.4 and 4. I guess this is their own statute or their own rules. Wisconsin cited 8.4, but then they actually typed this in. We have not charged moral turpitude in over 30 years. And then West Virginia gave a lot of information here. So again, like, I'm not quite sure what all of this is, but this is something, again, I can like PDF this document and share it with you, and you can look it up as you wish to learn more about how they charge these other two misconduct categories. But they did add this sentence down here, and I think this is maybe citing a case within their state. Moral turpitude has been defined as this. So for your information, we asked also everyone if you have data to share on the percent of attorneys that are being charged with misconduct, however you define it, and no one said they had data to share except for one state, and they only shared a link to a big report, and we haven't had an opportunity to go through it yet. So not a lot of data out there to get a sense of like what percent of respondents are being charged under even 8.4. Okay, so that's all I have about those states, and the reason why I invited Randy to come present is because, as you can see, the majority of the other states are saying that they use Model Rule 8.4 as the way to charge moral turpitude, and so, or to get at those issues. And in the process of doing research, I saw that California adopted Model Rule 8.4 in 2018. So I thought it would be worthwhile to have Randy come and share with us this legislative history. So can we turn to that now? Would be okay?
Lisa, if I could just clarify, when you say the majority of other states, you mean
that answered.
That responded, which were 11.
Yes.
Okay, just to be clear.
Mm-hmm. Okay.
Hi, everyone. Nice to see you.
Hi, Randy.
I'm really here just to tell you about my own recollection of the adoption of our California version of ABA Model Rule 8.4. ABA Model Rule 8.4 really follows the history of the ABA's treatment of the topic of moral turpitude, which I believe was present even as early on as the ABA Model Code as part of Disciplinary Rule DR 102. So the ABA has had moral turpitude referenced in their misconduct rule since the Model Code. What happened with the ABA Model Rules, however, is that they took the concept of moral turpitude and they somewhat relegated it to a comment, I'm afraid. And so I provided Lisa with a red line strikeout version showing the changes to ABA Model Rule 8.4 with regard to the rule that we now have in California. And previously, the only component of 8.4 that we really codified in our rules was the assisting or inducing violation standard. And so when you see in the red line that that's sort of an existing standard, that was really the only thing we had. We did not have a version really of 8.4 in the current form that we have now. And if you look at the red line, you will see that in the comments, the principal comment addressing moral turpitude, ABA model comment 2, is omitted. And it is because the language of that comment is what is used to, I'll put it this way, again, these are just my personal observations, but to favor the application of the 8.4 standards, subdivisions above in the black letter of the rule, as opposed to perhaps the general concept, whether it's in discipline common law or it's a remnant of whatever model code provision they might have had if it's still in their black letter. But this comment was designed to say that moral turpitude might not be the best standard because of the fact that it applies to personal conduct outside the practice of law that creates some, what I think the ABA believes to be some disclarity in terms of what conduct is or is not subject to discipline. And so they try to clarify that. We do not include any of that comment in our rule. Instead, if you look again at the red line, our comments 3 and 4 address the topic of moral turpitude by clarifying that we have statutory law that has long regulated conduct involving moral turpitude, and that the ability of the state bar to pursue discipline by charging those statutory provisions is retained. And so comment 3 refers to the conviction referral in terms of crimes and interim suspension for crimes involving moral turpitude. And that is preserved and cited in the comment 3. Also mentioned there is a separate doctrine, other misconduct warranting discipline, and that is also preserved and retained and perpetuated through this comment 3. And then specifically under comment 4, the rule says a lawyer may be disciplined under 6106 for acts involving moral turpitude. And so, unlike some jurisdictions that may have adopted a version of Model Rule 8.4 with the intention or goal of diminishing the application of any sort of prior concept of moral turpitude in favor of charging the specific provisions of the rule, that is not what we did in California, at least to my mind. In fact, when I reviewed the court filing that was submitted by the State Bar, there's a lengthy overview and introduction of the entirety of the rule amendments. And so, of course, this was the first comprehensive amendments to the rules cover to cover since 1992. And so their ability to help the court track what we were doing with these rule amendments was important. So this overview introduction attempted to break down some categories of revisions in those rule amendments. And so we had the category of enhancing competence, where we mentioned the new diligence rule 1.3, rules strengthening fiduciary duties, and we mentioned the new provision in 1.15 for handling advance fees, rules that help access the justice, and we mentioned the rule expressly permitting limited scope representation. But the one that's important to us here is that the rule filing to the court included a category essentially for rules that affirm existing California professional responsibility standards that really are exceptionalism in terms of diverging from what is in the law of any other state. And what we list there is what, and I'm speaking to knowledgeable people, Ellen and Sean, things like the pure referral fees among lawyers in different firms, the fact that our confidentiality rule really only has one exception, not the multiple exceptions of Model Rule 1.6. And notably, we include a reference to the new Rule 8.4, and we specify for the court that we are retaining moral turpitude, 6106, that we're retaining the concept of conviction referrals under 6101, and that we're including, again, the separate doctrine of other misconduct. And so that, to me, taken together with which is pretty clear in the comment language itself in the rule, even though you really can't, and I would never hazard to say, I know what was in the heads of the justices when they adopted our Rule 8.4, my own personal view is that it's relatively clear to me that the policy decision made in the adoption of 8.4 was to have it add to the public protection that the State Bar is giving and not replace the public protection that is provided by the statutory schemes. And so long way of saying the legislative history to me when I review it, including the language of the comments in the rule itself, strongly suggests that both the court and the board and the Rules Revision Commission all understood the adoption of this rule as perpetuating the moral turpitude standard as opposed to replacing it. And I'm happy to answer any questions.
Well, this isn't a question, but Randy, I just want to clarify. I don't know if you're looking at this from the same perspective that was proposed when we established this working group. The purpose of the working group was never to come up with a proposal to strip moral turpitude out of the rules of professional conduct. That's not the issue. Rather, the issue is that in application, moral turpitude now is being charged in, what is it, more than 1/3 of the state bar disciplinary cases. This is a new development. Historically, a charge of moral turpitude was reserved for the types of crimes that are referred to in our comments, and or the type of dishonesty, corruption, wholesale disregard for the lawyer's obligations. And currently, the argument is frequently made that the respondent's conduct constitutes gross negligence. Gross negligence equals moral turpitude. Therefore, because respondent was grossly negligent, there must be a violation of 6106 found. And that's not the way the respondent's bar reads the case law. And that's not the way that historically moral turpitude has been included as a separate and additional disciplinary charge in state bar discipline cases. If moral turpitude is found, then under the standards, the discipline is increased. So it's a very significant issue, not relating to whether acts of moral turpitude should not constitute a disciplinary offense, and not suggesting that there should be no violation based on an act of moral turpitude, but rather that we should give more attention to the increase in the charging of moral turpitude as an additional violation, the charging of moral turpitude in cases in which there is no dishonesty, the charging of moral turpitude in DUI cases, where we're talking in some instances about a single conviction of DUI. I mean, I'll just say anecdotally, I had a case where the matter was referred to the review department. My client had been convicted of 3 DUIs in another state more than 15 years ago. Those convictions were expunged as if they had never been charged. And this person is like the poster child for sobriety, been sober for 15 years. And we ended up getting that case dismissed by the review department on the basis that the expungement in the state where the convictions occurred vitiated the conviction. But this was fought vehemently by OCTC, to the point that in their reply brief, they even requested that the review department place this lawyer on immediate interim suspension based on moral turpitude. And I think quite rightly, the review department dismissed that case. And I think that that's indicative of the way in which the term moral turpitude and the analysis of what constitutes moral turpitude, is being pursued now recently, not so recently, but for a period of time. And in keeping with my, now I'm sure everybody's, sick and tired of me saying the mantra that I think one of the principal reforms that can be made in the discipline system is improving efficiency and expediency and getting more cases to resolve. One of the key reasons that cases don't resolve, despite the fact that the respondent is willing to stipulate the culpability, and despite the fact that the parties agree on level of discipline, is that the state bar insists that there be an additional stipulation to moral turpitude. And for a lot of respondents, that's the tipping point. And that's why cases don't resolve or drag on and on and on, because we can't get to a disposition unless the respondent agrees to stipulate to moral turpitude. So I believe that's the issue that was raised by Ed and myself, why we're having this working committee. And I think that it doesn't really go to the legislative history of 8.4 or the fact that nobody's suggesting that we, obviate 6106, but as a practical matter, it's a question of application.
Well, and thanks for clarifying that, because it certainly improves my understanding of what you're trying to address here. I will make one other observation that in sort of rule amendment years, the fact that the new rules became operative 2018, is still a relatively recent vintage for, I think, cases to work through the system. So I can't speak to charging or anything of that sort, but I do think it will take some time to see to what extent 8.4, where it has the specificity that might be different from the discipline common law in terms of moral turpitude, how that plays out. I think it just takes time for those cases to come up and get charged and move through the system and see what the courts say about our 8.4. It is kind of relatively new for us.
If I could just comment related to some of the things that Ellen said. I mean, I think what I'm challenged with is the notion that this is a new development, that the charges of moral turpitude are a new development. Because I don't think, and I could be wrong, somebody from Orion can tell me, but I don't think that we have data on, for example, the rate at which moral turpitude was charged, 7, 10, 15 years ago to compare it to. I know that there's a feeling, but I just don't know that there is data to support it. And even if there was, I guess what I would wonder is whether that's commentary on, the philosophy of the office or the discipline system, or just the misconduct of respondents that we're seeing. I think what would be troubling would be if we brought charges and those kind of charges and with frequency in a statistically significant way, they were dismissed at the trial level. And then that would suggest that there may be an issue. But the data that we have seen thus far has not borne that out. And even in the cases that were shared, I mean, many of the cases, the moral turpitude charges were dismissed pursuant to a stipulation, which obviously then the parties were able to resolve the case. And for whatever reason, the moral turpitude charge was dismissed. I don't think it's clear, and probably in the four corners of the document, as to why that is. But I'm struggling because I'm just not seeing the issue here, at least that the data supports that there is an issue. I'm not seeing it.
Well, I have a suggestion. I think there is data, and I think it's fairly easy to track. We have the State Bar Court Reporter, and if somebody just runs a check on under the index 6106, and the cases where it's found and not found, I think you'll find that a very small percentage of cases even charge 6106. I don't think it's a perception. I believe it is a true fact, and I think that a very easy and available source to track that is to let's look at the history of reported State Bar Court decisions by looking at the State Bar Court Reporter, and I think that will give us a very straightforward comparison of the percentage of cases in which moral turpitude was involved, and as compared with the number of cases where it's charged now. I think that'd be pretty easy for staff to do. And the other thing is, I mean, Melanie, maybe this wasn't your suggestion, but if you're suggesting that lawyers are suddenly more dishonest, or these days lawyers are more apt to engage in moral turpitude than in the past, that's not borne out by the data either. Every year we have roughly, what is it, the same 600 to 1,000 lawyers disciplined year in, year out. And there's no empirical data to suggest that lawyers are becoming, less honest and more corrupt. So I don't think that should be even, mentioned as the reason why moral turpitude is being charged now.
Well, I think the point is that we don't know that, one, we don't know if it's being charged at a more significant rate. And even if it is, what the reason for that would be.
Well, I think the reason is that it increases the level of discipline. And so if moral turpitude is charged as an additional offense, then that gives the prosecutor the ability to argue that under the standards, the discipline has to be higher. Whereas if you remove moral turpitude from the mix, then typically I mean, unless you're talking about misappropriation or something that nobody's going to argue doesn't involve moral turpitude anyway. But for the what you might think of as the lower level or less serious charges, if moral turpitude is not in the mix, then the level of discipline is much lower and it's much easier to resolve those cases.
Okay, so I hear a request for data, and we can explore whether or not we can get that. You know, we can talk about, you know, see how many years we can go back to see if there's any changes in the percent of cases that go to state bar court that have at least one moral turpitude charge. Sean, do you want to add anything to this discussion?
No, no, I have to think about it. I'm not sure.
Okay. Okay, okay, so I think we have a game plan moving forward then. Staff is going to explore these whether there's data available to see if we can see any trends in the share of cases that have moral turpitude charges, whether it's same, declined, or it has increased. And we will resend a link to the folder just to ensure everyone has it. And then when we schedule the next moral turpitude meeting, perhaps we'll do a little reminder to please review those cases. And Ellen, what I would suggest is like review those 12 cases, and maybe there's a few there that you would like to draw your let Justin know, and then
Thank you. I will.
And then he can let the whole group know that Ellen requests that you focus on these ones. She's going to plan to talk about those ones or something like that.
Yeah. Hey, Lisa, the one detail. Ellen had raised the issue of what, if I understood correctly, this is going back earlier in the meeting, that for her or other defense counsel to submit examples of cases that they want to discuss, could be a waiver of confidentiality. And then I guess they're public. We should check with OGC on that. But my sense, Ellen, is that while generally state bar emails are a public record and subject to disclosure under the PRA, there are a lot of exemptions, like deliberative process exemption and information that is otherwise already protected, like confidential disciplinary files, I don't think would be waived simply by emailing it internally within the bar. But I check with OGC, and also if we're discussing information that's in files that are non-public, unless they can be, anonymized, then we might have to consider a closed session or something. So
yeah, or I'll talk to Melanie about this, but I was thinking maybe it wouldn't violate any of the, public interest rules if I were to characterize the respondents by letters, A through P or whatever it is, and then give the case numbers to Melanie so that she can, have the, or, and Lisa, whatever, but so you would know specifically what case, but it wouldn't be a public revelation of either the respondent's name or the case number, because, especially those who have had their cases dismissed, or as I say, admonitions or private approvals imposed, the last thing they want is to have their name out there in any way. So maybe we can work that out.
yeah, and even if it's public discipline, I think there's sensitivity to discussing, individual cases with the names of the respondent in a forum like that, because it just gives it a prominence that is a little unfair unless the respondent consents to it.
Yeah, definitely no names. Definitely. Okay. Okay, I think we're done here for today. Does anyone else have any comments or questions about our path forward?
Thank you.
Thank you.
I wish you all a wonderful holiday season.
You too.
Yes.
Happy holidays.
Happy holidays, everyone.
Mhm.